Welcome to my presentation on using Assured Trading Standards Advice to your advantage. Trading Standards Assured Advice is something that NFOP, the National Federation of Property Professionals, set up some time ago, and they've been obtaining advice from trading standards for some time. And what I wanted to do was to explain how, whether you're a member or you're not a member of NFOP, you can actually get some benefits and get some advantages from this advice. Now, some of you will be NFOP members already, and some of you won't. So hopefully you'll get something from the next 10 or 15 minutes from this presentation. But let's have a look at what the arrangement with trading standards is. So, Trading Standards Assured Advice is given by trading standards when they are appointed as a primary authority. So anybody can set it up, any organisation can set it up, and what it means is if you meet a few conditions that trading standards set and you follow their advice, then you can take advantage of it. Obviously paying their fee is the main requirement for trading standards. NFOP have got this relationship set up with Warwickshire Trading Standards, and they've obtained quite a few opinions and obtained advice on a selection of issues, which we'll talk about in the next few minutes. For NFOP members, then these opinions can be relied upon 100%. If NFOP members follow that advice, then it doesn't make any difference what the situation is. If they follow that advice, then they will be protected and they cannot be prosecuted by any other trading standards authority. It's a great situation to be in, and something where organisations can get some real benefits from it. So, can it help non-members? Well, in theory, it can, because the advice only works for agents that are within the scheme, and you have to sign up to the scheme to be part of it. So, in theory, no advantage whatsoever. However, in practice, it has some advantages for all agents, and I'll explain why. If two agents with offices next to each other, for example, in the same town, it's not unusual. One's a member of NFOP and part of the primary authority setup, and the other one isn't. Trading standards will not prosecute the one that isn't part of the setup if the two agents do the same two things. If one follows the assured advice and the other follows the assured advice, they will not take action against one rather than the other. It will give protection to both agents. It would be nonsense to think that trading standards would ever contemplate taking such a step. And you'll see as we look at some of the advice later on what I actually mean in relation to that. So, you could say that non-members of NFOP have more advantages than members. This is because you can follow the advice and you'll get some protection. Obviously, there's no guarantee that you won't be prosecuted if you're not a member of NFOP's primary authority setup. The only guarantee is for those people who are members. But as I've said, I don't think it's going to come to a prosecution, even if you're not a member. So you can follow it and you will get some protection. But as you are not a member, then if you don't follow it, then it can't be used against you, because in theory it only applies to members of that primary authority arrangement. And so the truth is, non-members perhaps get more advantages than members. So let's have a quick look at what they've given advice on so far, and you can pick up this on the NFOP website. I'll give you the link to get this assured advice at the end of the presentation. But they've given various pieces of advice on potential consumer protection regulation issues, and some of which are good, some of which are, well, all I can say is I would say they're nonsense, but we'll talk about those because I want to give some examples of how non-members can get advantages from using this advice. So they're given various CPR pieces of advice. Displaying business legal names to comply with the Business Names Act. That's a piece of advice they've given, which is fairly straightforward. Correctly displaying your agency fees. We've done a presentation on agency fees in this round of webinars, and so you'll have got some advice off me on that. But you can have a look at trading standards advice, which will give you even more information. How should an agent market a property in a dual agency situation? When is it unfair or undesirable to withhold an offer? When do cancellation regulations apply? Again, we've done a presentation on that, but you can go to the assured advice and get a bit more information on that. When do cancellation rights apply to auctioneers? They do apply to auctioneers, and so you have to have a look at that advice to find out when trading standards think it does apply. Various pieces of advice on energy performance certificates have been asked for and given. How and when can a property be advertised as new on the market? Again, that was part of my consumer protection presentation in this webinar series. What information should be disclosed when marketing a leasehold property? That's an interesting piece of advice. According to trading standards, you have to advertise a whole host of information when it's a leasehold property, and I would guarantee you that 90% of agents are not complying with that requirement because it's not practical. But anyway, what requirements exist for property photographs used to market properties? Again, they've given advice on that. I'm not sure it's great advice, but it's there. Minimum requirements for describing a room as a bedroom. When can an attic space be described as a bedroom? When can a property be described as south-facing? That's an interesting one, an interesting question, an interesting little answer, fairly straightforward as far as I can see. Should an agent disclose maximum occupancy details? That's generally in relation to lettings situations, but again, interesting piece of advice. How to legally canvass against a competitor. The Advertising Standards Authority are always giving advice on that, so I don't really think trading standards are needed to give the advice, but they have. NFOP have asked them a question, so they've given the advice. So, before looking at some of this advice, I just want to explain that I don't agree with a lot of the advice that's been given. I think quite a lot of it is wrong. I think quite a lot of it is naive on trading standards' part because they don't understand agency. And I think in some cases they've just given stupid advice. And I think it's important that you understand this, because if you want to take advantage of this, then you have to know what's good and what's bad and how to use it. So really you've got to look at everything and make some decisions about whether you think it's good or bad advice to follow. So let's have a quick look at some bits of advice that you may or may not think are useful. I'm not convinced they are, but here we go. Trading standards suggest that deaths that occurred inside a property are not material information. If they're not material information, then that means they don't need to be disclosed under the consumer protection regulations. And so, what a great piece of advice. A death in a property isn't material information. You don't need to mention it. I hope you're all gasping at that advice, because it's ridiculous. If somebody has been brutally murdered in a property, I think that's material information. I think that quite a lot of buyers would want to know about it. Now, you can follow trading standards advice here. It's there in black and white, it's not material information, but I think you've got reputation issues here. I think there's a potential for somebody to say, you didn't tell me about this, I'm going to complain to the Ombudsman, I'm going to complain to trading standards, I am going to complain to the press. You can imagine what the press might do if they got a complaint about a horrendous death that took place in a property and the agent wasn't disclosing it. So I think you've got to make decisions about every situation that arises, and you may decide that a death is not material information because it happened some time ago, because it happened of natural causes, and it's not material information, you may also decide that you need to disclose a particular piece of information because it is material and it's going to damage your reputation if you don't. But that gives you the options to choose either route in order to take advantage of the advice that trading standards are giving you. Another one is the vendor or the previous tenant, it could be in either case, is a convicted paedophile. Do I have to tell potential purchasers? Trading standards said, in our opinion, the fact that a vendor is a paedophile is not material information. Therefore, you don't need to disclose it. Again, I would think some of you are gasping at that because whilst you might say, yes, that's correct, because those individuals are moving out of the property, so therefore it's not relative to the property. In my view, it is relating to the property because there will be idiots out there that will still believe that somebody with this conviction lives at the property, and they may well take retributional steps against the property, never mind the people who they see living there. There are lots of cases of that taking place. In addition, those offences may have taken place in that property. If they have taken place in that property, there will be a lot of consumers who would not want to live in that particular property. So, therefore, I think it is material information. So, I think, again, as a non-member of NFOP, you can use this advice if it suits you, but in truth, you can also say, no, I'm not going to follow this in this situation because I think it's material information, and you can disclose the information. Be careful about disclosing information about individuals because you can have potential breaches of the Data Protection Act, which we may well cover in a later webinar. Now, I'll just finish on this particular one. Given that trading standards have said that deaths in property are not material information, the paedophile vendor is not material information, they then go on to say that covenants on a property is material information. So if you can't keep a caravan on the property, you've got to disclose it. I find it rather strange that they would say, you can't keep a caravan on the property, so therefore it must be disclosed. The seller is a convicted paedophile who committed offences against children in this house, but you don't need to disclose anything about it. There you go, maybe that's a little naive and a little stupid from trading standards perspective, but that's the advice that they've given. Have a look at the advice on the NFOP website. You can see the link on the slide now. You'll find that some of it is very interesting, some of it potentially useful, and some of it maybe not. As a non-member of NFOP, I think you can use it to your advantage. Thanks very much.